necessarily have to protect the whole of the product. You can do a part. So for example, here with Allbirds, they've protected the sole of their shoe, that design, as opposed to the whole top of the shoe there in combination. They've also covered doing some surface decoration on the shoe as well here. So it's not limited to what the actual shoe looks like. As mentioned, we can also do logos. There's also computer icons as well and things like that.
So I think tyre manufacturers, what do they use then? Because they have tread patterns, don't they? Is that patents and design?
I would say it's potentially both, wouldn't you, Jag? So they can have technical characteristics like trying to disperse water better, that sort of thing. Compounds where the tires like needs to be stickier, for example, more hard wearing, that sort of stuff. But then also there is a potential aesthetic side to it, isn't there? You know you want your tires to look nice. Maybe like if you're putting like the white writing on the side.
No,
You
I
know,
was,
for
I
like
was thinking of the
Hankook.
actual the tread
Yeah.
pattern, the actual the zigzags and the lines down it. They might have a technical effect. The paint might be to disperse water safely out the. I don't know. Anyway.
So in that situation, I'm sure Greg's about to say, but the thing about this is something to think about because clients can get this a bit mixed up a bit in the design. So it might be still worth protecting the design of that track on the tire because of the way it looks. But actually, in the law, there's an exclusion for aspects of the product which are solely there for the technical effect and dictated by the technical effect. So if a certain shape on there has to be that way and only that way on the track, then that's not part of the protection that you've had by the design.
Yeah.
But if there's some freedom available about how you create the design, even though it has some technical aspect, you could still get a design registration. So you could get the design registration, but it wouldn't give you the best protection.
Yeah.
So it's worth getting the patent side as well, and that can often be with things like vacuum cleaners as well. They're part of the shape, like the Dyson cleaners. You get that kind of cyclonic shape. At the top, you're going to get conical shapes due to the cyclonic separator on it, where they've protected the design because of the unique look of it, but actually they've got separate protection for what the cyclones are doing.
Yeah.
And people can get that confused sometimes, thinking I've got design registration, I'm protecting my product, but it's not actually protecting what it's doing. Yeah.
Cool. So moving swiftly on. Yeah. No.
Yeah, we're running on a bit, so yeah.
Okay.
Sorry, I keep butting in and making it last longer when I shouldn't be. I should keep quiet and then.
So moving on to copyright. Copyright protects loads of different things. It's generally, artistic things, non-literary written works such as software and the like. So it's the actual wording there of the software rather than the kind of concept that the software embodies, as it were. When you actually run it. So that's why it's important to consider patents alongside this. Sound and music recordings, film and television recordings, broadcasts, and all these different things. It's not a right that you have to apply for, like patents, trademarks, or designs. It automatically exists, and it protects against copying, as the name suggests. It's a relatively narrow form of protection. So, for example, with the software side, if someone independently created something which did the same thing, then copyright wouldn't protect against that. It's got a relatively long duration. Copyright is generally 70 years from the end of the calendar year of the creator's death. And all businesses will have some form of copyright. Yes. And this is me again. Ownership of IP rights. So I think Ed's going to talk about this briefly, or he's going to talk about it after, but briefly. Generally, an employee generates an IP right in the course of their employment. It belongs to their employer. If someone's commissioned, i.e. an outside consultancy or the like, then it'll be them that owns the IP. So it's important to get an agreement in place or think about that if you're using them. And then there might be some agreements clauses around grant funding, investment agreements, and IP ownership. So it's important to check those when you apply for these sorts of things. Right, and I think this is me again now, Jag. So IP and third parties, in particular, freedom to operate. So we talked a lot about getting IP rights. The other side of it is, am I going to infringe someone else's IP rights if I go and do what I want to do? Like if I want to adopt that branding, if I want to make this product, if I want to make it look this certain way. So what you can do is you can go and get professional searches done to try and check and make sure that you've kind of cleared the way and have freedom to operate in these fields. So that is something that you can do. Is there anything you want to add there, Jag?
Yeah, and it comes at quite a lot. It can be quite expensive and complicated potentially. I know, like Innovate UK, they often have a question around what freedom framework have you done and things like that. And there's ways you can quickly check. Now, what it normally says a rule of thumb, maybe in terms of your main competitors for your particular business or your technology, just to check quickly in the name of that competitor what IP rights they have can be enough to sort of say, well, I've done some level of checking, but I've not gone so far to do a full analysis at this stage. But that might be enough to sort of give some reassurance to any third parties you're working with.
And then moving on to ownership of IP. So this is something that I'll talk about again, but it's important to make sure that if you need access to IP, that you do have those agreements in place to make sure that you can do what you want to commercially. Yeah, it's as simple as that. Make sure that if you're going to enter into agreements to kind of develop stuff with people, that the ownership is going to vest where you think it is. If you're going to collaborate with people and that sort of thing.
You often you get someone saying, don't you, like entrepreneurs, they start, they're keen to get going, they get their friend to help out with a bit of code, they get another friend to help out with some prototyping. There's no written agreements in place and stuff. And then when IP is created, whether that's copyright in the code or maybe an invention when someone's prototyping, because you don't have any written agreements in place about who owns the IP, the default belongs to them. So it could be you go later down the line to try and file a patent application or get an investor on board, and they ask you, oh, okay, oh, this is really interesting. Who did this, this, and this? And then when you tell them, like, okay, but who owns the IP? And then you can come a bit unstuck because suddenly you've got this messy situation. The investor says, I don't want to get involved because you don't actually own what I need you to own. So that I'm sure Ed will talk about that a bit later.
Yeah. So that was a bit of a whistle stop tour. Thank you.
Wow, fantastic, guys. There was one question. How do you register copyright, or is that automatically arising once you've written a piece of work?
So you don't need to register copyright. It's not a thing that you really do. It's an automatic right. So the most important thing for you to do is to prove your ownership of it. So keep really good records. Make sure that everything's dated. If you've got it saved on a computer, make sure that all the metadata is there for that as well. Is there anything you'd add to that, Jag?
Yeah, and maybe any ownership agreements, so like who authored it and how they're related to your business, and you own the right, from this, like the software developer, where's the agreement, the contract that says that you own the copyright, what they've done, and all the rest of it. And that can be quite a bone of contention if there's a dispute about copyright infringement. Yeah.
Okay, so I think the advice is there are loads of different ways to secure IP protection, and it's worth having a conversation very early on to make sure you're on the right track to do that correctly, and actually make sure you make funds available to look after that protection, because it does cost money, but it can be absolutely an invaluable investment.
Yeah.
So yeah, thank you very much, guys. Absolutely fascinating. We could have done an hour and a half on that quite easily, couldn't we?
Yeah, so sorry guys if we've gone on a little bit, but there's a lot to cover, hopefully. So
yeah,
yeah,
and half of it's my fault for asking questions, so I do apologize.
I'm not going to say that, but
yeah. Okay, thanks very much. I'm going to do 2 minutes on Patent Box. I tell you what, should we get Ed to do Patent Box? I'll do Patent Box in just 2 minutes because I've got 10 slides, but 8 of them are a worked out calculation, folks. So you'll be able to just get copies of that to see how all the steps work. Okay, Jag Greg, thank you very much. And I'll do my piece on a Patent Box. Hopefully that's gone through. Come on. Yeah, there we go. Okay, very briefly, Patent Box. HMR, so the government is great. The UK is actually a great place to do innovation. You can get grants to pump prime it. You can get R&D tax credits to thank you for having invested in R&D. And then once you start launching a product, then Patent Box rewards you for commercializing it. In a sense, what it does, it looks to reduce the corporation tax that you would pay on profits associated with the sale of a product that has patented components in it, and I'll come on to that in a minute, down to as little as 10%. However, when it got first launched some 15, 18 years ago, it was really quite generous. In 2016, they changed all the legislation. It's not quite so generous and it's a lot more complex, but it can still give you that headline saving of up to 10%. So it is well worth considering. So to be eligible, you do need a patent, and that needs to have been applied for, and you need to be commercially exploiting it, and then you can what's called elect into patent box. The patent needs to be filed. It doesn't need to be granted, because what you do over the years until it's granted, you accrue the benefit in your accounts, and then when it gets granted, you can then cascade it back and get the benefit. So it doesn't need to be a granted patent for you to take advantage of patent box, but you don't realize that benefit until it is granted. I hope that makes sense. As an entity, you must be liable to pay UK corporation tax. So typically that is a limited company. You must own the patent, or you must own the exclusive rights to some patented technology. So, and that's what I mean by exclusive. It might be territorially, so you're just exploiting it in the UK. It could be in a certain market, but it has to be an exclusive license and not to be shared with others. And it is patents, but it also covers other descriptions for plants and seeds and other bits and bobs. But essentially, it's a patent that is applicable in the UK, the EU, and various other jurisdictions. That does include Japan and America. Question there: how do you define commercially exploiting it? So that could be you licensing your IP to somebody else and they're exploiting it and you're receiving an income, or it's you selling product with that involved. There is something called a meaningful piece of IP. An example would be if you've created a really super duper resistor that you build into electronics and you build that into a new telephone. It's such a minor component, although it's got a patent on it, it's actually overall not affecting the overall performance of that telephone. Therefore, it may not be a big enough component. If you developed and patented a new microphone that you were putting into that telephone, the microphone is a substantial piece of how a telephone works, and a far better microphone will give you market advantage. So that would be a great component. Whereas just a resistor tucked inside one of the circuit boards would not count. So there's a meaningful test. So you need to consider that that's the minor or the major part of the product. If you have patented a process that you use to manufacture a product, then products that you manufacture through that process, the sale of those can be part of the patent box regime. You do have to think very carefully, as Jack said and Greg said earlier, with a patent, it could just be a UK patent. What is the cost of applying for that and maintaining it? And what happens? What's the benefit from the patent box generated? Does it more than cover your patenting fees? What is the reason why you've gone for that patent? Is it purely to protect it, stop other people copying? Is it purely for doing patent box? You really need to think carefully about the return on investment. And it might be better that you don't do a patent, you go down the trade secret route and you don't bother with patent box, because you're not putting into the public domain what the nitty-gritty of your invention is, but it means that nobody can really copy it or re-engineer it, but you don't get the patent box benefit. It is that balance you need to think about. And I think it's worth modeling. If you have got a patent on a product or a significant component that goes into a range of products, how many of those am I likely to sell? And what might be the profit on those? And just do a quick calculation to understand, actually, patent box does generate some £30,000–40,000 a year of saving. We've got to do this. It makes sense. You also need to think, if I do get the patent, actually, it might not be me so interested in patent box. If I license my technology, lock, stock and barrel, the people who buy it might want that patent in order to get patent box. So it can be an important part of the negotiation if you're licensing out your IP. You will need to apply for the patent or acquire that exclusive license. You have to write to HMRC a letter that says, I'm electing into patent box. If your profits are fairly small, you can do what's called elect into the small claims treatment. And that's just a very easy way of working out one of the steps in the calculation. And what you need to make sure is that you can track as accurately as possible the product sales and ideally the cost of goods sold for each of the products that you sell with a patent in and those without a patent in. So you can justify exactly what the profit streams are and hence what the claim is. So I'm just going to talk through these, but I'm not going to go through them in detail because we're running out of time. These are the key costs, the key steps you'd need to go to if you were to make a claim. You have to have quite a lot of evidence to support all of this. I'm just going to whiz to the end to show you what, in this example, the worked example, what the benefit was. So for these guys, 2 million of which represents 72% of their turnover, cost of goods and some other bits, they were making just about 40% profit. Then you go through these other steps all the way down to the patent box deduction, and basically patent box has saved this company some £60,000 a year in tax, which it's not the full 10% it is could it cut down to, it cut it down to 12.5%. And you know, for £50,000 it's worth a couple of weeks work to save £57,000. 10 days work to sort this out a year, that's the best day rate that company is going to win. So really well worth looking into. Do a fag packet number, do model it, understand the cost of both the patent side and the record keeping against the amount of sales you're expecting in. And that's all I want to say. So there weren't many questions, that's good. Ed, are you there?
I am, Sam. Yep.
Good. Right. Who's running through your slides? Is that me or is that Joe? I can do it.
Either or, I'm happy. I'd assume Joe, but happy either way.
Equally good looking. There we go.
Yes.
I'll be your beautiful assistant, Ed.
Okay, lovely. Thank you, Sam. Thank you very much again for the patent box talk, and Jag and Greg, thank you for the IP rundown. I will hopefully keep this motoring and relatively sort of pragmatic and practical in the context of third-party involvement and considerations when it comes to licensing in. Those are the sort of headline subjects. So let's get into it. So again, this is something that's that Jag and Greg have touched upon. So I don't particularly see any need to get into it any further. That there were reasonably common themes that apply to all types of intellectual property, and it's something to be aware of when and if you task a third party to engage in any kind of development. The likelihood, if not the inevitability, is that the ownership, certainly first ownership of that particular development or IP generation will be the party who's effectively commissioned or tasked to carry out the required work.
I think is the exception there the employee generally.
That's an exclusion. Yeah, so that's a circumstantial exclusion whereby if it's done in the context of someone's role as an employee in the course of employment, then yes, it will automatically vest in the employer. But that's not the case when you're dealing in a sort of third-party arm's length contractual arrangement. So you need to consider what you need by way of returned rights in an IP sense to not only use the deliverable, but potentially own it.
And that's something that you can negotiate when you engage that third party, isn't it? You can say, right, on full payment, I want those rights.
Absolutely. Yeah. I mean, from the point of view of the parties, the third party who's doing the contracted work, they will obviously want to reserve ownership until such time as the full payment was received for the work done. You should never be under the illusion that the full payment itself is what transfers the ownership. That's not the case at all. There needs to be a very specific and express written assignment provision into the contract that takes care of the assignment of ownership at a certain point. Or at the very least that you get a license to use what has been developed, or some background or underlying elements of what has been developed, if in fact they belong to the third party contractor who's engaged in the development, and it forms part of their sort of crown jewels as such and tools of trade. But we'll come to that in a minute or two. So again, in this context of third-party involvement, it's vitally important. And again, I think Jag and Greg touched upon this to make sure that the information that's being disclosed to either assist with the process or the services that the third party is requiring, or in some other way provide them with the grounds or the subject matter for them to work with. There needs to be a contractual arrangement that governs the confidentiality that needs to be applied, and actually it goes back even further to the point of having the discussion to determine whether the parties can work with each other. Again, if that's going to be meaningful, there's going to need to be some degree of confidential information disclosure. And again, if what is at stake is potentially patentable going forward, then again, that is vitally important.
And I noticed you mentioned there about tension with academics. Is that because students, so you engage a university to do some work, they get a student to do it, students are not under the same obligation as, because they're not an employee of the university? How does that work?
That is part of it, Sam. Yes. So you need to consider whether you're contracted with all parties involved at different levels of connectivity. If in fact there isn't a relationship such as an employment relationship upon which you can rely, but I would tend to be overcautious and attempt to get direct contractual obligations for confidentiality to be observed between all parties, just to make sure you have that direct contractual connection should you need to enforce or issue an injunction or whatever it may be. But equally, there may be needs to, again, conversations pre-contractual could be successful or non-successful. So you also need to consider whether obligations of confidence need to survive, the conversations or need to survive the end of the contractual relationship should that come to pass.
Yeah.
So okay, let's move on. Again, this is probably one of, well, I guess it's trying to debunk a couple of things. A confidentiality agreement is worth the paper it's written on, regardless of whether that who propagates that myth that it isn't. It certainly puts you in a far better position than if you had relied on taking it before the courts in a common law position and proving that there is a situation that requires and necessitates confidence to be adhered to, and in fact the information has the necessary quality to be confidential information. So you can imagine, again, standing up before the judge and trying to evidence all of that and being certain about your position. It just won't happen. So again, the certainty comes from documenting it clearly in a well-provisioned confidentiality agreement. But at a practical level, I'd be very, very careful about what it is I have to disclose in the context of a given situation, and I would be very reluctant to, well, certainly don't reveal everything, and be quite careful about keeping back certain elements that are particularly sensitive or particularly trade secret premised or are extremely valuable from the point of view of its know-how that's required to work a potential patent or a patent application, because again, the patent itself will give some information away, but it won't necessarily give all of the really credible and necessary information at a granular level that's needed to get the best results. Okay. Again, once you've had those pre-contractual discussions, you obviously can move straight to contract if you feel that's appropriate. But actually, there's quite a neat little mechanism of getting a full understanding and consensus of material terms. And actually, you can do a number of other things with that as well by sort of getting exclusivity of negotiation periods. You can, again, just facilitate the process by sort of trying to remove pressure from it while at the same time ensuring that there are elements that are vitally important that the consensus is reached, so that there isn't a mistake that's going into the full contract negotiation once you move to that particular document. But at the same time, that there are binding elements that are recognised, such as the governing law that will apply to the heads, and also the agreement that results. There are potentially cost-based or fee-based items that relate to the negotiation that you can get on a contractually binding level. Confidentiality equally, again, in the context of further negotiation, and periods of exclusivity, obviously. So not to be underestimated as a document, particularly if there's quite a complex end agreement that's going to need to be sort of borne out, as it were.
Yeah, and this, the heads of terms, is equally applicable whether you're licensing in, licensing out IP, but also whether you're wanting to contract with somebody who's going to do some major R&D with you. Both are equally applicable before you just leap in and just sign a sales order, off you go, crack on and do it.
Without question. Yeah, licensing in, licensing out, cross licensing. Yeah, the whole patch.
Yeah.
Okay. And again, these are the types of things that then may result when it comes to sort of engaging third parties. I'd like to think they're all sort of fairly straightforward in context and nature. That there are some very pragmatic ones there, like manufacturing, whether that's prototype manufacturing or full scale. The agency of distribution type agreements tend to apply when you're dealing with cross-border arrangements where you need a sales presence with local knowledge. Consultancy speaks for itself. That's the administration and acquisition of expertise. Clearly, we'll talk more about IP assignments and licenses as I work through this. But again, if you look at what we just mentioned, Sam, those can be quite significant items at an R&D and collaborative cross-licensing or even commercial joint venture level, or in fact corporate joint venture.
Yeah, I came across an interesting one. It was a major PLC were developing some technology, and we got them a grant, and they were working with a partner who was doing a cable connection for subsea stuff, and so the PLC had to design their unit to work with this connector, and so they became symbiotic. So if they fell out, who gets residual right to the IP generated through the grant? Because if they fell out with the cable manufacturer, they couldn't then use their device. So that was really quite that kind of thing is really tricky to sort out, isn't it?
It is tricky to sort out, and again, that's part of the exercise. While the parties are amicable and friendly towards each other, and heaven forbid they become unfriendly, but it's vital that you address it in advance, because an agreement to agree after the fact is not only likely to fail and not get anywhere, but it's actually legally unenforceable. So you have no leg to stand on unless you actually start again dedicating your thoughts to it very early on. Again, another reason for a heads of terms to get to the nitty-gritty of these sorts of things and then allow them to be translated accurately into a binding agreement.
Okay, next one.
Okay.
Yeah.
So with again, those particular types of agreement or contexts in mind, you actually have to understand what it is that you want to generate and what it is you're trying to create, I suppose, out of the third party involvement. And I mean, to an extent, it may be pre-existing. It may, to an extent, be something that's the subject of development and generation. But with that, you need to determine between yourselves what it is that you ultimately want to achieve. And it might be outright acquisition of ownership if it's something that's new and predicated on background IP that you've supplied to the third party, or in fact, it's wanting to utilize something that pre-exists or something that pre-exists and can be developed further and form with your own IP or your expertise or whatever it may be that you want to apply to it a more marketable and profitable proposition. So again, at a pragmatic level, you need to determine what it is you need, what rights you need going forward, and whether those need to be unfettered, or if you're happy to have them fettered to some extent, what terms apply to the license that you receive, both when it comes to nature, by way of exclusivity or non-exclusivity, by way of length, by way of geographic scope or field or sector-based scope. And clearly there'll be a financial proposition in there around license fees and royalty fees going forward. So that needs to be considered as well in the context of whether you acquire, because ultimately that particular price is a one-off hit normally and far more significant than a licensing arrangement fee. But again, you may have a policy that you want to adhere to. Equally, that may be the case with a third party who's got a body of IP that you want to potentially access. So the considerations are extensive, and it's again going back to that heads of terms piece. It's vitally important that you have that discussion rather than get into a beleaguered contract negotiation because the parties are sort of fairly diametrically opposed. But you have to be realistic about this sort of thing as well. It's utterly inappropriate for you to think you can acquire ownership of something that is actually fundamentally important to a third party contractor's business across a wider client base. That just, unless you're acquiring the business to facilitate the ownership of the IP in question, then I think you're probably going to have to resort to a licensing arrangement, and that may well need to be one that is probably reasonably standardized as far as that third party is concerned. So but equally, you need to think about this idea. Well, we'll come to it in a minute, but this idea of what gets developed and the concept of improvements, even if you're tasking someone quite clearly and crisply with just a manufacturing proposition, for example, they may well uncover certain things in the course of that with their know-how and expertise that actually amounts to improvements, and who then becomes the owner of those sort of things. So it's always a consideration in any particular environment where a third party involvement is needed.
I was involved with one licensing deal for some technology into cosmetics industry, and patented. They were looking to license in the patent, but the deal we were structuring was not only for the use of the product at the time, but because it gave them information and opened their eyes to other ideas, it was what level of ongoing evolution of that design into other product areas could the license still go back into.
Absolutely right, Sam. I mean, you need to dedicate your thoughts as to whether it's actually appropriate for the license that you have in respect of the IP at that state, at that time, to continue to be the terms upon which something is licensed. Because again, goodness knows where the improvement sort of takes it, as it were.
Yeah.
And again, in terms of fields of application, that could well be totally inappropriate and unfit for purpose, actually. So you do need to be clear about at what point in time. I know it's convenient to try and bulk everything into a license that already exists, I suppose, but it may not be the best measure. And actually, at a financial level, from the party's point of view, who has ownership, that it is highly likely not to be, in fact. And again, you need to just from the point of view of licensing, particularly in an exclusive position, if you're conceding rights to that extent, which effectively amount to ownership, but you still retain ownership in the background. It's just that only one person is allowed to use it for the period of time of the license. That's a fairly significant rights sacrifice, and you need to make sure the minimum revenue returns, minimum measures in there to make sure you're getting the optimization of that rights sacrifice.
Yeah. Okay. Next one.
Yeah, please.
All
Yeah,
right, there we go.
you. And this is the premise of mixing up a sort of an IP position, where this probably has more relevance to a almost a cross-licensing arrangement or a collaborative arrangement, when both parties are contributing background IP that exists already to a particular project to determine whether foreground IP can be generated to one or other party's use and benefit. And it's vitally important that you. I think I will say this and commit to it. Please don't go down the route of joint ownership, if at all possible. Please just think very carefully about who's best placed in view of the IP that's been contributed to own IP, and who is best placed to obtain a license in respect of it. And that might be resource-led as well, in view of who's best placed to continue to pay for the fees applying to the registered elements IP-wise of the IP in question. It may be who's best placed to take it forward in terms of commercial exploitation, and therefore you need to look back at how that becomes suitably unencumbered to allow that to happen. But please get an ownership position with one of you and an appropriate license position with another.
Yeah.
The reason I say that is because joint ownership, then you can get into what's known as a trap of domestic enjoyment in a lot of different types of IP. This will apply, and actually you get to a point where you need the consent of the other party to do anything. Let me rephrase that. You can do what you like with it as an individual entity, but if you are going to be doing anything that involves a third party, and that's inevitable when it comes to getting it into market, you're going to need the consent of the other party, and they're going to need to be happy with the terms to provide that consent. And that's where you get into real problems if you haven't sort of engineered or thought about that idea and actually provided for it in the relevant contracts. Or if you've just left it to an agreement to agree, or you've just not addressed it at all. That's when things become very, very, very ugly quite quickly in many cases.
Yeah. Again, it's the Donald Rumsfeld, isn't it? You can't. There's known unknown. There's unknown unknown. So trying to do this on your own, it could open you into an absolute world of pain. Or
absolutely
trying to do it on the cheap with people who are less experienced. It is that breadth of experience and knowledge that. It's like everybody who's spoken today. It's that breadth of knowledge and what they bring to the parties is why you invest in those people to do the right job, isn't it? And it's so easy to trip yourself up.
Yeah, absolutely.
Yeah.
And again, background IP is a vitally important thing. It's not to be forgotten about. You can't just simply leap forward with your own background IP and the foreground that arises. You're going to need inevitably the background IP that the other parties contributed as a foundationary element. So there's going to need to be some degree of licensing. Now you can work on the scope of that license and make sure, again, it doesn't trip up what you're trying to achieve at a commercial level. And that's often, one of the key considerations when dealing with universities and their background IP. But again, you can get into all kinds of considerations there, including the university taking stakes in companies if a brand new company's been set up and spun out to, facilitate the commercialization.
Yeah.
Okay.
Okay.
And this is the headache. I mean, this is always going to be the subject that why you're getting into the collaboration in the first place. Hopefully there is going to be this outcome, but it needs to be thought about in advance as to where ownership lies. And as I say at the top, please don't go down a joint ownership route if at all possible. Get yourself to a position thinking about those factors that I list there as to who's best placed to own, and then being realistic and reasonable about the licensing terms that apply to the other party.
Yeah.
Okay, I'm again not going to.
I think we've done
much.
that one, haven't we?
Yeah, we have. Okay, and yeah, amongst what Jag, Greg, and I have said, I think those are some reasonable headlines.
Yeah, and is that it?
That's it.
I don't know. I've clicked on to the next one. Okay, Ed, fantastic. Yeah, no, you know, an absolute whistle-stop tour, but it's just opening people's eyes into, even if whether you're licensing out or licensing in, you got to consider this kind of thing. And it's asking the bigger. It's like a prenuptial agreement, isn't it? You got to sort out all those nasty bits that make you feel uncomfortable, but once it's in place, you may never have to look at it again because everybody knows.
It is. Yeah, I mean, you don't want to be treading on people's toes. Equally, some people may be stagnating with IP, and actually, it is better placed in someone else's hands. Equally, you know, they may want to take it in different directions. So those rights need to be reserved to that extent, and others need to be afforded if someone else is taking something and able to work it in a different direction. It really is. It is all down to purpose and intent as to why the parties are getting involved. But you need to be open and very full and frank about it. And again, that NDA-based pre-contractual discussion premise leading to heads of terms that allow it to be really thought through and proper consensus reached is vitally important. But there needs to be full disclosure and recognition of the IP that people rely upon. Don't over license or sort of over concede in terms of heaven forbid you cede ownership in an assignment position from in relation to IP that you need and actually have some basis for keeping afterwards. Or if you're going to do that, at least get the license back to afford your continued usage of that in that respect. But you know, it's not all impossible. It just needs to be thought about well in advance. And properly provided for, and to some extent with some forward judgment about who's best placed to commercialize, who's best placed to take it this direction or that, and who will need what if they aren't going to be commercializing. Who will need continued rights from a research, academic, maybe even a development position. Yeah,
fantastic. Okay, Ed, thank you very much indeed. That's been a whistle-stop tour. I think that terrifically useful information there. Thank you very much indeed.
Pleasure.
Okay, everybody. Thank you for staying with it. It's been a bit of a session, but hopefully it's been really, really useful to you, everybody. Certainly, I've done this talk 2 or 3 times and I've found it absolutely fascinating. There's always stuff I learn every single time. So I think it's just been superb. The final workshop, that's in 3 weeks' time, on Thursday the 15th. That's all about the commercialization side. So we've done about money, we've done about people, we've done about product and what you're trying to sell to people and how to protect it and how to protect your licensing it in or out. The final one is all about commercialization and getting you some money for the great ideas you've had. So please make sure you register for that. Thank you very much to Shakespeare's for sponsoring the Innovation Challenge, and for Foresters for sponsoring this workshop. Bulba kind enough to sponsor the final workshop, so that's terrific. But thank you, Jag. Thank you, Ed. Please do apply to the Innovation Challenge. It's a fantastic way to get really positive PR for your company. There's some fantastic ways to help you grow your business within the support packages for the winners. So really do have a look at that and make sure you do apply. So that's that. Okay, just once more, thank you very much. We've actually managed to finish bang on time, so that is absolutely awesome. I think, Ed, I've never known you speak so quickly.
Apologies, but, that's the Northern Irish kick.
But thanks so much, everybody, for attending. Thank you to all the speakers. Thank you to our sponsors. And the recording will be available, and we're going to be circulating the slide. If you want to get in touch with the speakers, please let us know. I think we're going to be circulating some of their emails. Lovely. We'll see you on the next workshop. Thank you very much, everybody. Thank you.
Thank you, everyone.
Cheers. Bye bye.